Interpretation of Statutes, Part 3. Definitions and the General Clauses Act 1897. Statutes often contain a definition section, that is Section 2, which explicitly defines the most important terms used in that statute. However, some statutes omit a definition section entirely or fail to define a particular term. The literal rule, which is also known as the plain meaning rule, attempts to guide courts faced with litigation that turn on the meaning of a term not defined by the statute or on that of a word found within a definition itself. According to this rule, when a word does not contain any definition in a statute, it must be given its plain, ordinary, and literal meaning. If the word is clear, it must be applied, even though the intention of the legislature may have been different or the result is harsh or undesirable. The literal rule is that what the law says instead of what the law means. This is the oldest of the rules of construction and is still used today, primarily because judges are not supposed to legislate, as there is always the danger that a particular interpretation may be the equivalent of making law. Some judges prefer to adhere to the laws of literal wording. Before a draftsman begins drafting a bill, he must keep in mind the provisions of the General Clauses Act 1897. The Act contains definitions of some words and also some general principles of interpretation. If the bill that is being drafted uses words which are defined in General Clauses Act 1897, it may become necessary to take note of the definitions in that Act and find if that definition could apply or if a different definition should be incorporated into the bill. Article 366 of the Constitution of India also contains some definitions which may have a bearing in some cases. Of course, where words are not defined in the Act or in the General Clauses Act, the courts may interpret a word by resorting to dictionaries or by context, or setting in which the words are used by applying the principle of nociter a socis. That means, nociter a socis means that the meaning of the words is to be judged by the company it keeps. Okay, know it by its society. Know yourself by your friends, something like that. Some definitions contain legal fictions by including certain other things within the meaning of a word to achieve the purpose of the statute. Sometimes the definitions contain explanations or exclusions of certain other things. Sometimes they also contain certain provisos. Some definitions use the word means, which shows an intention to give an exhaustive definition, while certain definitions of the words shall include or shall be deemed to include, which definition is not exhaustive. Again, where the definition contains specific words and general words, courts can resort to principle of ejusdem generis. That means in a group, ejusdem generis. That means that when a particular words pertaining to a class, category, or a genus are followed by general words, the general words are construed as limited to the things of the same kind as those specified. That means belonging to the same group, ejusdem generis, such as war, disturbance, or any other cause, or arms, ammunition, gunpowder, or any other goods, bleaching, mercerizing, organdy processing, or any other process. But the use of the word otherwise does not attract this principle, as for example, in the following definition of the workman. Workman means any person who entered into work under a contract with an employer, whether the contract be by way of manual labor, clerical work, or otherwise. Here it does not belong to the group of labor or clerk. It will be something other than the labor and clerk. Sometimes words which are not defined in the opening part of a statute are defined in the body of the statute or in separate parts or chapters of the statute. The general rule of construction is that when any central act is not expressed to come into operation on a particular day, then it shall come into operation on the day it receives the presidential assent. According to General Clauses Act 1897, when this act or regulation made after the commencement of this act repeals any enactments hitherto made or hereafter to be made, then unless a different intention appears, the repeal shall not a. Revive anything not in force or existing at the time at which the repeal takes effect. B. Affect the previous operation of any enactment so repealed or anything duly done or suffered thereunder. C. Affect any rights, privileges, obligation or liability acquired or incurred under any enactment so repealed. D. Effect any penalty, forfeiture or punishment incurred in respect of any offence committed against any enactment so repealed. E. Affect any investigation, legal proceeding or remedy in respect of any such right, privilege, obligation, liability, penalty, forfeiture or punishment as aforesaid, and such investigation, legal proceeding, or remedy may be instituted, continued, or punishment may be imposed as if the repealing act or regulation had not been passed. Where any central act or regulation made after the commencement of this act repeals any enactment by which the text of any central act or regulation was amended by the express omission, insertion, or substitution of any matter, then unless a different intention appears, the repeal shall not affect the continuance of any such amendment. In any central act or regulation made after the commencement of this act, it shall be necessary for the purpose of reviving either wholly or partially repealed expressly to state the purpose. Importance of illustrations or practical examples. In the body of certain statutes, particularly those enacted in the last nearly 150 years, there has been a practice of giving illustrations below the section as practical examples. We find a good number of them in Indian Evidence Act, Indian Contract Act, and Indian Penal Code. This practice is now practically out of use. Illustrations are part of the Act but cannot be used to modify the language of the section. Indeed, Section 114 of the Evidence Act contains illustrations which refer to various presumptions of the fact which are mainly based on human conduct. Next heading, Rules of Statutory Interpretation, Legalism and Creativity. Much jurisprudential writing on interpretation in legal reasoning is concerned with how to strike the right balance between the conserving and creative elements in interpretation, and with the constraints which are and or should be operative upon judges as they undertake this balancing act. Some theorists claim that such concerns about how one ought to interpret the law indicate that it is part of the way that we think about this practice, that we regard rival interpretations as subject to objective evaluation as good or bad, better or worse, correct or incorrect. On this view, characterizations of interpretation which attempt to impugn the objectivity of such evaluations are to be understood as revisionist accounts, which attempt to persuade us that all is not as it appears to be, with our practice of judging interpretations to be good or bad, better or worse, correct or incorrect as we currently understand it. Legal fiction is defined as a legal assumption that a thing is true, which is either not true or which probably is false. An assumption of law that something which is false is true. A state of facts exists which has never really existed. This is legal fiction. What is legal fiction? Legal fiction is defined as a legal assumption that a thing is true when it is either not true or probably it is false. Then, assumption of law that something is false when actually it is true. And a state of facts exists which has never really existed. A legal fiction is a device by which the law deliberately departs from the truth of things for some reason. Example, a foreigner was treated to be a Roman citizen for the purpose of jurisdiction. Legal fiction is treated in the provisions of an enactment by using the term is deemed. The deeming provision is for the purpose of assuming the existence of fact that does not really exist. In New India Assurance Company versus Complete Insulation Private Limited, the Supreme Court held that legal fiction created under Section 157 of the Motor Vehicle Act 1988, the transfer of the third-party insurance is deemed to have effect from buyer to seller. In Bengal Immunity Company Limited versus State of Bihar, the Supreme Court that the legal fiction should not be extended beyond its legitimate limits. In Pandurang Vinayak versus State of Bombay, the Supreme Court held that for the purpose of legal fiction, the word ordinance is to be read as enactment. In Bombay Corporation versus CIT Bombay, Section 43 of the Income Tax Act provided that under certain circumstances, an agent is for all purposes of this Act deemed to be an agent of non-resident person. Such agent is deemed to be an SSC. In Avatar Singh versus State of Punjab, it was held that rules framed in contravention of the Electricity Act 1910 are separate, and hence theft of electricity is not an offence under IPC. Legal fiction is an important subsidiary rule of interpretation of statute. It is useful in deciding case where certain things are presumed to exist in fact of their non-existence. Legal language, legal riddles and logic. The key to this issue lies in interpretation's dualistic nature. That is, it has both a backward-looking conserving aspect and a forward-looking creative one. This dualism would seem to indicate that in interpreting the law, judges both seek to capture and be faithful to the content of the law as it currently exists, and to supplement, modify, or bring out something new in the law in the course of reasoning from the content of law to a decision in a particular case. In turn, this would seem to indicate that interpretation, because of its dualistic nature, has a role to play in both legal reasoning in sense A, that is, reasoning to establish the existing content of the law on a given issue, or legal reasoning in a sense B, namely reasoning from the existing content of the law to a decision which a court should reach in a case involving the issue which comes before it. One legal theorist who adopts exactly this approach and so views the interpretation in legal reasoning as straddling the divide between identifying existing law and developing and modifying the law is Joseph Raz. According to Raz, the fact that interpretation has a role to play in both of these activities assists in explaining why we do not find a two-stage or clearly bifurcated approach to legal reasoning in judicial decisions. Judges do not first of all engage in legal reasoning in sense A, having recourse only to legal materials, and then having established what the existing law is and determined how far it can take them in resolving the instant case, then move on to a separate stage of legal reasoning in sense B, which requires them to look to extra legal materials in order to complete the job, because much of their reasoning is interpretative and interpretation straddles the divide between legal reasoning in senses A and B. Rules of interpretation. Over time, various methods of statutory interpretation and construction have fallen in and out of favor. Some of the important rules of statutory interpretation are: 1. Primary rules, legislative intention rationale. 1. Literal rule, that is plain meaning rule. It means that the statute ought to be interpreted using the ordinary meaning of the language of the statute unless the statute explicitly defines some of its terms otherwise. In other words, the law must be read word for word and it should not divert from its true meaning. When words of a statute are clear, plain or unambiguous, that is, they are reasonably susceptible to only one meaning, the courts are bound to give effect to that meaning irrespective of the consequences. In J.P. Bansal v. State of Rajasthan 2003, SC observed that the intention of legislature is primarily to be gathered from the language used, which means that attention should be paid to what has been said as also to what has not been said. As a consequence, a construction which requires for its support addition, substitution, or removal of words, or which results in rejection of words as meaningless, has to be avoided. This is in accordance with the case of Crawford v. Spooner 1846, where Privy Council noted that the courts cannot aid the legislature's defective phrasing of an act, they cannot add or mend, and by construction make up for the deficiencies which are left there. In Kannallala Sur v. Parammindhi Sadhu Khan, Judge Gajendra Gatkar says that if the words used in statute are capable of only one construction, then it is not open to the courts to adopt any other hypothetical construction on the ground that such construction is more consistent with the alleged objective and policy of the Act. In M.V. Joshi v. M.V. Sampi, relating to Food and Adulteration Act, it was contended that the Act does not apply to butter made from curd. However, SC held that the word butter in the said Act is plain and clear, and there is no need to interpret it differently. Butter is butter, whether made from milk or curd. Advantages. Proponents of the plain meaning rule claim that it prevents courts from taking sides in legislature or political issues. They also point out ordinary people and lawyers do not have extensive access to secondary sources, and thus depending on the ordinary meaning of the words is the safest route. It encourages precision in drafting. Disadvantages. Opponents of the plain meaning rule claim that the rule rests on the erroneous assumption that the words have a fixed meaning. Words are imprecise, leading justices to impose their own prejudices to determine the meaning of a statute. However, since little else is offered as an alternative discretion confining theory, plain meaning survives. Sometimes the use of literal rule may defeat the intention of Parliament. For instance, in the case of Whitley versus Chappell, the court came to the reluctant conclusion that Whitley could not be convicted of impersonating any person entitled to vote at an election because the person he impersonated was dead. Using a literal construction of the relevant statutory provision, the deceased was not a person entitled to vote because he is already dead. So, copying him or impersonating him is no crime. This surely could not have been the intention of Parliament. However, the literal rule does not take into account the consequences of a literal interpretation, only whether words have a clear meaning that makes sense within that context. If Parliament does not like the literal interpretation, then it must amend the legislation. It obliges the courts to fall back upon standard common law principles of statutory interpretation. Legislation is drawn up with these principles in mind. However, these principles may not be appropriate to constitutional interpretation, which by its very nature tends to lay down general principles. It is said that it seems wrong to parcel the Constitution as if it were a finance act. Clearly, the literal approach has another disadvantage in that one judge's literal interpretation might be very different from another's. Casey says, what may seem plain to one judge may seem perverse and unreal to another. It ignores the limitations of language. To place undue emphasis on the literal meaning of the words is to assume an unattainable perfection in draftsmanship. Judges have tended excessively to emphasize the literal meaning of statutory provisions without giving due weight to their meaning in a wider context. Next, mischief rule. This rule attempts to determine the legislator's intention. Originating from a 16th century case in UK, its main aim is to determine the mischief and defect that the statute in question has set out to remedy, and what ruling would effectively implement this remedy. Case Smith versus Hughes. The mischief rule is used by judges in statutory interpretation in order to discover legislature's true intention. It essentially asks the question, by creating an act of parliament, what was the mischief that the previous or existing law did not cover and this act covers? This rule was developed by Lord Coke in Sir John Haydon's case, that is called Haydon's rule also. Mischief rule is also called Haydon's rule. When it was stated that there were 4 points to be taken into consideration when interpreting a statute. What was the common law before making of the act? What was the mischief or a defect for which the common law did not provide? What remedy the Parliament has resolved and appointed to cure the disease of the Commonwealth? And what is the true reason of this remedy? The application of this rule gives the judge more discretion than the literal and the golden rule, as it allows him to effectively decide on Parliament's intent. Legislative intent is determined by examining the secondary sources such as committee reports, treatises, law review articles, and corresponding statutes. The rule was further illustrated in the case of Smith versus Hughes, where under the Street Offences Act 1959, it was a crime for prostitutes to loiter or solicit in the street for the purposes of prostitution. The defendants were calling to men in the street from balconies and tapping on the windows. They claimed they were not guilty as they were not in the street. The judge applied the mischief rule to come to the conclusion that they were guilty as the intention of the act was to cover the mischief of harassment from prostitution. This rule is of narrower application than the golden rule or the plain meaning rule, in that it can only be used to interpret a statute and only when the statute was passed to remedy a defect in the common law. This rule has often been used to resolve ambiguities in cases in which the literal rule cannot be applied. As seen in Smith versus Hughes, the mischief approach gave a more sensible outcome than that of the literal approach. Advantages. The Law Commission sees it as a far more satisfactory way of interpreting acts as opposed to the golden or literal rules. It usually avoids unjust or absurd results in sentencing. Disadvantages. It seems to be out of date as it has been in use since the 16th century, when common law was the primary source of law and the parliamentary supremacy was not established. It gives too much power to the unelected judiciary, which is argued to be undemocratic. In the 16th century, judiciary would often draft acts on behalf of the king and were therefore well qualified in what mischief the act was meant to remedy. However, such is not the case anymore. Next, golden rule. It is a compromise between the plain meaning rule, that is literal rule, and the mischief rule. Like the plain meaning rule, it gives the words of statute their plain ordinary meaning. However, when this may lead to an irrational result that is unlikely to be legislature's intention, the judge can depart from this meaning. In the case of homographs, where a word can have more than one meaning, the judge can choose the preferred meaning. If the word only has one meaning and applying this meaning would lead to a bad decision, the judge can apply a completely different meaning. This rule of statutory interpretation allows a shift from the ordinary sense of the words if the overall content of the document demands it. This rule is a modification of the literal rule. It states that if the literal rule produces an absurdity, then the court should look for another meaning of the words to avoid absurd result. The rule was evolved in Parkby, who later became Lord Wensleydale, in Beckey versus Smith, and in Gray versus Pearson, who stated that the grammatical and ordinary sense of the words is to be adhered to, unless that would lead to some absurdity or some repugnance or inconsistency with the rest of the instrument, in which case the grammatical and ordinary sense of the words may be modified so as to avoid the absurdity and inconsistency, but no further. It is a very useful rule in construction of a statute, as it allows to adhere to the ordinary meaning of the words used and to grammatical construction, unless that is at variance with the intention of the legislature to be collected from the statute itself, or leads to any manifest absurdity or repugnance, in which case it allows the language to be varied or modified so as to avoid such inconvenience. This rule may be used in two ways. It is applied most frequently in a narrow sense, where there is some ambiguity or absurdity in the words themselves. For example, imagine there may be a sign saying, "Do not use lifts in case of fire." Under the literal interpretation of this sign, people must never use the lift in case there is a fire. However, this should be an absurd result, as the intention of the person who made the sign is obviously to prevent people from using lift only when there is currently a fire nearby. This was illustrated in the case of Lee versus Knapp, where the interpretation of the word stop was involved. Under Road Traffic Act, a person causing an accident shall stop after the accident. In this case, the driver stopped after causing the accident and then drove off. It was held that the literal interpretation of the word stop is absurd and that the requirement under the Act was not fulfilled because the driver did not stop for a reasonable time so that interested parties can make inquiries from him about the accident. The second use of Golden Rule is in a wider sense to avoid a rule result that is obnoxious to principles of public policy, even where words have only one meaning. In Bedford versus Bedford is another interesting case that highlighted the use of this rule. It concerned a case where a son murdered his mother and committed suicide. The courts were required to rule on who then inherited the estate, the mother's family or the son's descendants. The mother had not made a will, and under the Administration of Justice Act, her estate would be inherited by her next of kin, that is her son. There was no ambiguity in the words of the Act, but the court was not prepared to let the son who had murdered his mother benefit from his crime. It was held that the literal rule should not apply and that the Golden Rule should be used to prevent the repugnant situation of the son inheriting. The court held that if the son inherits the estate that would amount to profiting from a crime, then that would be repugnant to the Act. Thus, the Golden Rule implies that if a strict interpretation of a statute would lead to an absurd result, then the meaning of the words should be so construed so as to lead to an avoidance of such absurdity. A further corollary to this rule is that in case there are multiple constructions to effect the Golden Rule, the one which favors the assessee should always be taken. This rule is also known as the rule of reasonable construction. Advantages. This rule prevents absurd results in some cases containing situations that are completely unimagined by the lawmakers. It focuses on imparting justice instead of blindly enforcing the law. Disadvantages. The Golden Rule provides no clear means to test the existence or extent of absurdity. It seems to depend on the result of each individual case. While the Golden Rule has the advantage of avoiding absurdities, it therefore has the disadvantage that no test exists to determine what is an absurdity. This rule tends to let the judiciary overpower the legislature by applying its own standards of what is absurd and what is not. Rule of harmonious construction. When there are two provisions in a statute which are in conflict with each other, they should be interpreted such that effect can be given to both and the construction which renders either of them inoperative and useless should not be adopted except in a last resort. Case is Bengal Immunity Company versus State of Bihar. To repeat it, rule of harmonious construction. When there are two provisions in a statute which are in conflict with each other, they should be interpreted such that the effect can be given to both and the construction which renders either of them inoperative and useless should not be adopted. That is harmonious construction. Let all live. Subsidiary rules, legislative language ratio. Nociter a socis. When a word is ambiguous, its meaning may be determined by reference to the rest of the statute. Know you by your society, by your group. In Foster versus Dipwee versus Casson, the case involved a statute which stated that explosive taken into a mine must be in a case or a canister. Here the defendant used a cloth bag. The courts had to consider whether a cloth bag was within the definition. Under Nociter a socis, it was held that the bag could not have been within the statutory definition because Parliament's intention was referring to a case or a container of the same strength as the canister. In State of Assam versus R. Muhammad, Supreme Court made use of this rule to arrive at a meaning of the word posting, used in Article 233, Clause 1 of Constitution. It held that since the word posting occurs in association with the words appointment and promotion, it took its color from them, so it means assignment of an appointee or a promotee to a position, and does not mean transfer of a person from one station to another. Ejusdem generis. It is in a group. You belong to a group. When a list of two or more specific descriptions are followed by more general descriptors, the otherwise wide meaning of the general descriptors must be restricted to the same class, if any, of the specific words that precede them. Example, vehicles, in case of car, motor, bikes, motor-powered vehicles, and others, would be interpreted in a limited sense and therefore cannot be interpreted as including airplanes. In UP State Electricity Board versus Harishankar, Supreme Court laid the following conditions for the application of this rule. The statute contains an enumeration of specific words. Subject of enumeration constitute a class or a category. The class or category is not exhausted by the enumeration. A general term is present at the end of enumeration. There is no indication of a different legislative intent. In Ishwar Singh Bagga versus State of Rajasthan, 1987, it was held that the words other person is an expression any police officer authorized in this behalf or any other person authorized in this behalf by the state government in section 129 of the Motor Vehicle Act were held not to be interpreted ejusdem generis because mention of a single species of a police officer does not constitute a genus. Redendo singula singulis. When a list of words have a modifying phrase at the end, the phrase refers only to the last word. Example, firemen, policemen, doctors in a hospital. Here, in a hospital only applies to doctors and not to firemen and policemen. Redendo singula singulis. Noceter e socis, ejusdem generis, and redendo singula singulis. In Koteshwar Vittal Kumar versus K. Rangappa Baliga, it was held that the construction of the proviso to the Article 304 of the Constitution, which reads, provided that no bill or amendment for the purpose of Clause B shall be introduced or moved in the legislature of a state without the previous sanction of the President. It was held that the word introduced applies to bill and moves applies to amendment. Expressio unius est exclusio alterius. The expression means one person, thing, or a consequence implies the exclusion of all others. Variation would be expressio facit cessare tacitum. What is the expression puts an end to what is implied. Where a statute is expressly limited to certain matters, it may not, by interpretation or construction, be extended to other matters. Canon of restrictive interpretation states that where a statute, by its very terms, is expressly limited to certain matters, it may not, by interpretation or construction, be extended to others. The rule proceeds from the premise that the legislature would not have made specified enumeration in a statute had the intention been not to restrict its meaning and to confine its terms to those expressly mentioned. Dissimilum, dissimilest ratio. The courts may distinguish then there are facts and circumstances showing that the legislature intended a distinction or a qualification. Casus omissus. Casus omissus pro omissio habendus est. A person, object, or a thing omitted from an enumeration is a statute must be held to have been omitted intentionally. This needs two laws. In expressio unius, it is just the enumeration you are looking at, not another law. Ubi lex non distinguit, nec nos distinguere debemos. Where the law makes no distinctions, one does not distinguish. Where the law does not distinguish, courts should not distinguish. Strict construction. Let us see these Latin words once more. Subsidiary rules. Nauciter e soci. When a word is ambiguous, its meaning may be determined by reference to the rest of the statute. In Foster versus Defay, the case involved a statute which stated the explosion taken into a mine must be in a case or a canister. Here the defendant used a cloth bag. The courts had to consider whether the cloth bag was within the definition. Under Nauciter e socis, it was held that the bag could not have been within the statutory definition because Parliament's intention was referring to a case or a container of the same strength as a canister. In State of Assam versus R. Muhammad, Supreme Court made use of this rule to arrive at the meaning of the word posting used in the Article 233 Clause 1 of Constitution. It held that since the word posting occurs in association with the words appointment and promotion, it took its color from them and so it means assignment of an appointee or a promotee to a position and does not mean transfer of a person from one station to another. Ejusdem generis. When a list of two or more specific descriptors are followed by more general descriptors, the otherwise wide meaning of the general descriptors must be restricted to the same class, if any, of the specific words that precede them. Example, vehicles in cars, motorbikes, motor-powered vehicles would be interpreted in a limited sense, therefore cannot be interpreted as including aeroplanes. In UP State Electricity Board versus Harishankar, Supreme Court laid the following conditions for application of this rule. The statute contains an enumeration of specific words. Subject of the enumeration constitute a class or a category. The class or category is not exhausted by the enumeration. A general term is present at the end of the enumeration. There is no indication of a different legislative intent. So in Ishwar Singh Bagga versus State of Rajasthan, it was held that the words other person in expression, any police officer authorized in this behalf or any other person authorized in this behalf by the state government in section 129 of Motor Vehicle Act were held not to be interpreted ejusdem generis because the mention of a single species of police officer does not constitute a genus. Redendo singula singulis. When a list of words had a modifying phrase at the end, the phrase refers only to the last word. Example, firemen, policemen and doctors in a hospital. Here in a hospital only applies to doctors and not to firemen and policemen. In Koteshwar Vittal Kumar versus K. Rangappa Baliga, it was held that the construction of a proviso to Article 304 of the Constitution, which reads, provided that no bill or amendment for the purpose of Clause B shall be introduced or moved in the legislature of a state without the previous sanction of the President. It was held that the word introduced applies to a bill and moved applies to the amendment. Expressio unius est exclusio ulterius. The express mention of one person, thing, or a consequence implies the exclusion of all others. Variation would be expressio facit cessare tacitum. What is expressed puts an end to what is implied. Where a statute is expressly limited to certain matters, it may not, by interpretation or construction, be extended to other matters. Canon of restrictive interpretation states that where a statute by its terms is expressly limited to certain matters, it may not, by interpretation or construction, be extended to others. The rule proceeds from the premise that the legislature would not have made specified enumerations in a statute had the intention been not to restrict its meaning and to confine its terms to those expressly mentioned. Dissimilum dissimiliest ratio. The courts may distinguish when there are facts and circumstances showing that the legislature intended a distinction or qualification, not otherwise. Casus omissus. Casus omissus pro omisso habendus est. A person, object, or a thing omitted from an enumeration in a statute must be held to have been omitted intentionally. This needs two laws. In expressio unius, it is just the enumeration you are looking at, not another law. Ubi lex non distinguit, nec nos distinguere debemos. Where the law makes no distinction, one does not distinguish. Where the law not distinguish, courts should not distinguish. Now, next, strict construction. Strict construction refers to a particular legal philosophy of judicial interpretation that limits or restricts judicial interpretation. Strict construction requires the court to apply the text as it is written and no further. Once the meaning of the text has been ascertained, that is, court should avoid drawing inferences from a statute or a constitution. It is important to note that the court may make construction only if the language is ambiguous or unclear. If the language is plain and clear, a judge must apply the plain meaning of the language and cannot consider what other evidence that could change the meaning. If, however, the court finds that the words produce absurdity, ambiguity, or literalness never intended, the plain meaning does not apply and a construction may be made. Strict construction occurs when ambiguous language is given its exact and technical meaning, and no other equitable consideration or reasonable implications are made. Strict construction is the opposite of liberal construction, which permits a term to be reasonably and fairly evaluated so as to implement the object and purpose of the document. Remedial and penal statutes. A penal statute must be constructed strictly. This means that a criminal statute may not be enlarged by implication or intent beyond the fair meaning of the language used in the meaning that is reasonably justified by its terms. It is fundamentally important in a free and just society that laws must be readily ascertainable and reasonably clear, otherwise it is oppressive and deprives the citizen of one of his basic rights. An imprecise law can cause unjustified convictions because it should not be possible for the accused to defend himself against uncertainties. Therefore, an accused can be punished only if his act falls clearly into the four corners of the law without resorting to any special meaning or interpretation of the law. For example, in Sexaria Cotton Mills versus State of Bombay, Supreme Court held that in a penal statute, it is the duty of the courts to interpret the words of ambiguous meaning in a broad and liberal sense, so that they do not become traps for honest, unlearned, and unwary men. If there is an honest and substantial compliance with an array of puzzling directions, that should be enough, even if some hypercritical view of the law under ingenious meanings can be devised. If a penal provision is capable of two reasonably possible constructions, then the one that exempts the accused from penalty must be used rather than the one that does not. Whether a particular construction achieves the intention of the statute or not is not up to the court to think about in case of penal statutes. It is not apt for the court to extend the scope of a mischief and to enlarge the penalty. It is not competent for the court to extend the meaning of the words to achieve the intention of the legislature. If a penal provision allows the accused to go scot-free because of the ambiguity of the law, then it is the duty of the legislature and not of the courts to fix the law. Unless the words of a statute clearly make an act criminal, it cannot be construed as criminal. In Chunubhai versus State of Bombay, it is an important case in this respect. In this case, several workers in a factory died by inhaling poisonous gas when they entered into a pit in the factory premises to stop the leakage of gas from a machine. The question was whether the employer violated Section 3 of the Factories Act, which says that no person in any factory shall be permitted to enter any confined space in which dangerous fumes are likely to be present. The Supreme Court, while construing the provision, strictly held that the section does not impose an absolute duty on the employer to prevent workers from going into such area. It further observed that the fact that some workers were present in the confined space does not prove that the employer permitted them to go there. The prosecution must first prove that the workers were permitted to enter the space to convict the accused. Taxing statutes and the tax evasion. Tax is the money collected from people for the purpose of public work. It is a source of revenue for the government. It is the right of the government to collect tax according to the provisions of the law. No tax can be levied or collected except by the authority of law. In general, legislature enjoys wide discretion in the matter of taxing statutes as long as it satisfies the fundamental principle of classification as enshrined in Article 14. A person cannot be taxed unless the language of the statute unambiguously imposes the obligation without straining itself. In that sense, there is no reason why a taxing statute must be interpreted any differently from any other kind of statute. Indeed, SC in the case of CIT versus Shahzada, Nand and Sons observed that the underlying principle is that meaning and intention of a statute must be collected from the plain and unambiguous expression used therein rather than any notions which be entertained by the courts as to what is just and expedient. In construing a statutory provision, the first and foremost rule of construction is the literary construction. All that the court has to see at the very outset is what does the provision say. If the provision is unambiguous and if from the provisions the legislative intent is clear, the court need not call into aid the other rules of construction of statutes. The other rules of construction are called into aid only when the legislative intent is not clear. Lord Russell in Attorney General versus Carlton Ban illustrated categorically as, I see no reason why special canons of construction should be applied to any act of parliament, and I know of no authority for saying that a taxing statute is to be construed differently from any other act. However, as with any statute, a fiscal or a taxing statute is also susceptible to human errors and impreciseness of the language. This may cause ambiguity or vagueness in its provisions. It is in such cases the task of constructing a statute becomes open to various methods of construction. Since a person is compulsorily parted for his money due to tax, imposition of a tax is considered a type of imposition of penalty, which can be imposed only if the language of the provision unequivocally says so. This means that the taxing statute must be strictly construed. The principle of strict interpretation of taxing statutes was best enunciated in Rowlatt, Judge, in his classic statement in Cape Brandy Syndicate versus IRC. In a taxing statute, one has to look merely at what is clearly said. There is no room for any intention. There is no equity about a tax. There is no presumption as to a tax. Nothing is to be read in, nothing is to be read out, nothing is to be implied. One can fairly look at the language used. If by any reasonable meaning of the words it is possible to avoid the tax, then that meaning must be chosen. There is no scope for any inference or induction in constructing a taxing statute. There is no room for the suppositions as to the spirit of the law or by way of inference. When the provision is reasonably open to only one meaning, then it is not open to restrictive construction on the ground that the levy of tax is oppressive, disproportionate, unreasonable, and the word causes hardship. There is no room for such speculation because tax itself is for creating hardship. The language must be explicit. Similarly, penalty provision in a taxing statute has to be specifically provided and cannot be inferred. In A.V. Fernandez versus State of Kerala, Supreme Court stated the principle that if the revenue satisfies the court that the case falls strictly within the provisions of the law, the subject can be taxed. If, on the other hand, the case does not fall within the four corners of the provisions of a taxing statute, no tax can be imposed by inference or by analogy or by trying to probe into the intentions of legislature and by considering what was the substance of the matter. This does not mean that the equity and taxation are complete strangers. For example, in the case of CIT versus JH Kotla Yadagiri, Supreme Court held that since the income from business of a wife or a minor child is to be included as income of the SSC, the profit or loss from such business should also be treated as profit or loss from a business carried on by him for the purpose of carrying forward or set off of the loss under this section of the Tax Act. This interpretation was based on equity. However, it does not permit anyone to take the benefit of an illegality. This is illustrated in case of CIT versus Kurji Jinabhai Kotecha, where Section 24, Clause 2 of the Income Tax Act was construed as not to permit SSC to carry forward the loss of an illegal speculative business for setting it off against profits in subsequent years. This proves that even a taxing statute should be so construed as to be consistent with the morality, avoiding a result that gives recognition to continued illegal activities or benefits attached to it. Rule of strict construction applies primarily to charging provisions in a taxing statute and has no application to a provision not creating a charge but laying down machinery for its calculation or procedure for its collection. Thus, strict construction would not come in the way of requiring a person claiming an exemption. The provisions of exemptions are interpreted beneficially. Judicial activism, judicial process, and judicial restraint. According to Gray, the judges settle what facts exist and also lay down rules according to which they deduce legal consequence from facts. These rules are rules of law. Gray cites with approval the words of Bishop Hoadley. Whoever hath an absolute authority to interpret any written or spoken law, it is he who has truly the lawgiver to all intents and purposes, and not the person who first wrote or spoke them. Gray was criticized by Cardozo in the nature of the judicial process on the grounds of uncertainties inherent in his view that statutes are merely sources of law which judges utilize in exercise of a law-making function. In that view, says Cardozo, even past decisions are not law. The courts may override them. Law never is, but is always about to be. There are no such things as rules of principle. There are only isolated dooms. Today, legal uncertainty has reached unprecedented levels. Situation is evidenced by the widespread use of the terms such as complexity, obscurity, insecurity, indeterminacy, instability, discontinuity of the legal order. After a week or two of classes, first-year law students are rather surprised to learn how indeterminate or unclear the law is. They come to law school assuming that there is a body of knowledge about law that they are going to learn, and that this knowledge is out there written down in statutes and judicial decisions. By the end of the first year in law school, students come to think that almost nothing is clear about the law, that it all depends on how the courts interpret it, and that the best a lawyer can do is to make an educated guess about what the relevant court would do. They tend to think everything is up for grabs, but then once they start working as lawyers in a firm, the picture reverses. Lawyers quickly learn that most of the litigation is not about the kind of difficult legal issues they never have studied. But about humdrum matters of fact, what has really happened, who said this and did that. The law is much less clear than the people tend to think. It is much more clear than law students are led to believe, because they spend most of their studies focusing on the difficult or problematic cases that tend to reach the appellate courts. Next heading: Internal aids and external aids of interpretation.